Hi guys, it's Kathy. I apologize that it's been a while. I have gotten a lot of material in the last week, but I've been working. The only time I would have been able to stream was like at 3 a.m. And some people love those 3 a.m. streams. I personally love those 3 a.m. streams, but yeah, they don't do great, so I can't do them anymore. Maybe I have some things I'm gonna do at like 3 a.m., but they're like different kind of courses. Like we did the court case in Africa. I have one from England. That's probably going to be a 3 a.m. stream, not one of these because these are great. I don't want anybody to miss it. I got some great stuff today. Let's start with the guy who, is high in custody, high on life. Here we go.
Correct.
And you'll hear it better once it gets rolling. Don't worry.
And if she had it, how many months is that? Yeah, sure. All right. It's a day for day technically, right? It's 3 years. Is it what percent? 30%. Okay. I didn't get a chance to talk to you about that. So I'm kind of confused. Go ahead and run that with that, and it's all run concurrent.
Right. I've been handed an indication that Mr. Richardson is going to be entering a plea to 2022 CR 16 and 17. A violation of probation would be admit his violation and be revoked to serve the sentence. In docket number 2023 CR 28, he would be entering a plea of no contest to contraband in a penal facility, Class C felony, receive a sentence of 3 years to serve, Tennessee Department of Corrections. That would be concurrent to the prior case. Mr. Richardson, raise your right hand. Let's place you under oath. Thank you. State your full name for the record.
Brian Christopher Richardson.
Mr. Richardson, you have two different types of cases, so I want to deal with them separately.
Okay.
When you're violation of probation, I want to make sure that you understand your rights. Do you understand that you have a right to plead not guilty to that charge and to have a hearing in this court where the state would be required to prove to the legal standard that you had violated your probation? You understand you'd have the right to have a lawyer and have one appointed as we've done with the public defender. You understand if we had that hearing and I found you guilty, you could appeal whatever I did in your case to the Court of Criminal Appeals, have a lawyer appointed to help you with that appeal. You understand that by pleading guilty to the charge of violation of your probation, you're waiving your right to that hearing, to that appeal, and all I'm going to do is have you revoked to serve your sentence with credit for all the time that's set forth on this document. You understand everything I've explained on that one? You wish to waive your right to a hearing by entering a plea of guilty. And upon your plea of guilty, I order that you be revoked to serve your sentence with credit for time served according to this document. In the next case, you have a new charge of contraband in a penal facility. Have you seen or been shown a copy of those charges? Talked them over with Mr. Taylor, and you and he discussed the range of punishment you're facing as well as any possible defenses you might have. Well, it's indicated you want to enter a plea of no contest. That means you understand what the state's evidence is going to be. You're not going to admit you did anything, but you're not going to deny it. And you're going to let the state give me facts to support a finding of guilt in this case. Do you understand that?
Okay.
You understand, however, that you have a right to plead not guilty and to have a speedy and public trial by jury. You understand that trial, you would have the right to have a lawyer and to have one appointed as I've done with the public defender. You understand that trial, you'd be presumed to be innocent until such time if ever the state proves your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict will have to be unanimous before you could be convicted.
Yeah.
You understand at trial, you and your lawyer could confront and cross-examine every witness the state called to testify. You could bring in your own witnesses by using a subpoena.
Yeah.
You understand at trial, you'd be presumed to be innocent. You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
Okay.
You understand that if you went to trial and you were found guilty, you could appeal the conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal. You understand that by entering this plea of no contest, you're waiving your right to that trial and to that appeal. And all I'm going to do is approve the agreement your lawyers worked out. You understand that's going to result in a conviction, and that conviction is going to be on your record in the future to make more severe the punishment you'll receive if you're ever again convicted of a crime. Of course, it also results in 5 different counts of that indictment being dismissed as a part of the agreement as well. You understand everything I've explained to you? Do you want to plead no contest according to this agreement and waive your right to a trial?
Yeah.
Is your decision to plead no contest today voluntary? Yeah. Anybody forcing you to do this? You understand that I can't accept your plea unless I'm satisfied that there are facts to support it and that you are in fact guilty. I need to have facts given to me to support a finding of guilt. Now I want you to listen as the state tells me what their evidence would be if this case went to trial. You know?
Don't worry. We don't need to hear what he's saying. It's when the defendant starts to speak that it gets good.
Kenny Booth, the Houston County Sheriff's Department, he was asked if he had anything on a person. He denied that. A correctional officer searched with Richardson belongings, found 2 plastic bags containing licensed substance. One bag was found in the small pocket of his bibs. The other was found in a zipper pocket in his wallet. Substance weighed 0.9 grams, and a field tested both prospect for methamphetamine.
I'm not asking that you agree with those facts, but do you understand that's what the state's evidence would be?
I understand.
And do you still wish to plead no contest according to this agreement?
The only problem I have with that is they searched me 3 times, did not find anything. It wasn't until I was back in the holding and actually sent to Humphreys County and come back on this VOP that they hit me with these charges, saying that when they put my stuff into property, they found something with methamphetamine in it. And I thought to be introduction to a penal facility, it had to be while I was being searched. I'll tell you, I was high when I come in. I didn't know and I give up my stuff. So that's the only problem I have with this is this was days. This wasn't, if they had caught me red-handed with it, I won't have no trouble saying I done it. But they say that this
you're not saying you
5 to 7 days later.
You're not saying you did it. Your lawyer has worked out an arrangement for you to take this agreement if you want to. That you're not admitting, or you weren't admitting anything until you just started talking. But you
didn't have anything. I take these because it's in my best interest. I feel like to take these charges and run them concurrent. That's the way I believe.
Mr. Taylor, well, let me ask this question. Mr. Taylor has worked out an agreement for 5 different charges being dismissed as a part of this agreement. Yes. And I want you to tell me, do you believe he's done a good job of representing your family?
I believe he's done an adequate job.
Adequate.
Taylor, do you know of any reason he should not enter this plea? Anything further from the state? Then, Mr. Richardson, upon your plea of no contest and based on the facts presented, I find you guilty of count 2. Counts 1, 3, 4, 5, and 6 are dismissed as a part of the agreement. You're sentenced to 3 years in the Tennessee Department of Corrections to serve. That will be served concurrently with docket number 2022 CR 16. All right. Thank you.
You weren't admitting anything until you started talking. I love Judge Wolf. I just do. I just love his court. Okay. We're going to go to another court that I don't know why we don't see more of. He's great. And this pro se gets wrecked. I love it. It's just great all around.
Ready?
Yes,
okay.
Judge.
All right. So let's just, because lots of moving targets. My understanding is what we're here to do today is cover both sides 404B motions, correct?
Correct, Judge.
Mr. Phillips?
And
Your Honor, I just have a few concerns. I don't even know if we can even proceed today because there's other issues going on in regards to this case with these interference from the complainant.
You're muffled. I'm sorry.
I have COVID because my son got diagnosed with COVID on Saturday.
Okay, just so you know, that doesn't mean you have it. That means you've been exposed.
No,
go ahead.
I don't feel well, but
go ahead.
But I'll move this closer. So In regards to this case, Your Honor, the defense is unable to proceed in this matter. There's several issues, substantial and procedural defects in this matter that give rise to a dismissal on the January 14th, as well as the other one, 2201-3499 matter from 7/18.
Okay, you keep referring to the January 14th matter. I don't have a January 14th matter.
Oh, it's the extra information that was amended in the complaint for this same case, January 14th.
I only have one file. That file has a range of dates.
Yeah, the 6th
which was
date.
amended. What are the dates now? We've amended the complaint.
We have, Judge.
What's our window? I think it's July something.
It was from July 18th, 2022. For some reason, it's not written correctly, but it should be. And then it just includes July 18th to August 10th and then January 14th because of the request to amend it.
Okay. So there's a range from July 18 to August 10 of 22, and then one day of January 14, 23. It's all one case, all one charge.
It's 2 complaints, 1 case.
It's not 2 complaints. It's an amended complaint to include July 18 through August 10 and January 14.
Right, 1 complaint into the court, but the amended date is the January 14th.
I'm just clarifying your language. You said that case. There is only 1 case that's going to trial.
It's 1
It's a
case.
stalking charge. Those incident dates are what the prosecutor's using.
Right, and so
Okay.
I'm referring to January 14th of this year, which will be technically the 6th allegation date in regards to the 2300743 complaint with the police department, not the complaint in the actual court. However, that's added
Okay,
into
get to
this
your point.
complaint.
You're gonna make a motion to dismiss?
That is correct.
to your
However, I'm sorry.
Get to your point.
Okay, so in regards to that January 14th, it is known to the court, it is known to the prosecution that that did not occur, and there is police interference in regards to what's going
Okay,
on. police
okay, your
misconduct,
motion's
and
denied.
prosecute-
Your motion's
Sure,
denied. That's what
misconduct.
trials are for, Mr.
Okay.
Flores. I'm not
Okay,
gonna dismiss it because you say it doesn't happen.
I didn't say that.
Motion's denied.
Okay,
What's the next thing we have to get to before we do 404B?
very good. So in regards to that, again, I'm requesting Your Honor to recuse itself from the court, as well as this prosecutor recuse herself from this court for this court case, because it's unfair, it's prejudicial.
What's
there
unfair
is
and
pecuniary interest in the matter,
What's unfair
and
and
we're overlooking
prejudicial?
evidence.
What's unfair and prejudicial?
I'm sorry?
What is unfair and prejudicial about me hearing this case?
Oh, there's multiple events, multiple dates, multiple concerns in regards to this matter. I have
No,
not
wait
been
a
able to
minute, wait a minute,
secure
wait a minute.
evidence.
You can't just talk a bunch of crap. You've asked me to recuse myself because it's unfair for me to hear the case, correct?
That is correct. And I can
Okay.
prepare a motion and an
Okay,
affidavit.
hold on a minute. All right. First of all, this is a jury trial, so I'm not the trier of fact. Second of all, what's unfair about me being the judge on the case?
Oh, well.
Why
from-
am I biased? Why do you think I'm biased or I can't be objective? Tell me why I should recuse.
Right. So from start to present date of this matter, where Your Honor has heard the case, again, there's been procedural and substantial defects in this matter in regards to the arraignment. We can start there. The case started 9/30 of 2022. I was arraigned 2/22 of 22. The actual first trial date was scheduled for 2/7. Therefore, it speaks to exculpatory evidence not being heard, Brady violations, even to date, that has not
Okay,
been
once
addressed.
again, you're rambling. What was wrong with the procedure of the arraignment?
Oh, it was not held, as well as
You've never been
the
arraigned,
4 months. There was 4 months from 9/30 to 2/22.
and that was my fault because I'm biased against you. Is that what you're claiming?
It's not my fault,
It's got nothing to do with my bias or non-bias.
but there's, again, multiple.
Do you understand why you can request a recusal?
I do.
That there's something, personally, there's something that I've got an axe to grind, I can't be fair, there's an appearance of impropriety because you know my ex-girlfriend, or I don't know, but there's got to be some reason why I can't be fair and objective. The fact that you don't like the way we do things doesn't fit.
I
The
didn't say
fact that you
that.
want to control every step of the proceedings and I won't let you and you don't like my rulings, that's not a reason for recusal.
I didn't say
So
that.
unless you can give me something else, I'm going to deny that motion as well.
Well, that's fine, but I didn't say what you said. So other things in regards to the case, is Sixth Amendment a violation in regards to preparing the case?
Which once again is not a reason for recusal.
There's been interference in regards to that?
Okay, move on. I don't have all day. I'm denying your motion to recuse. What's next?
Recuse the prosecutor?
I can't recuse her.
Okay.
She doesn't work
Are you
for me.
going to recuse yourself?
Judge,
Go ahead, explain how you get assigned.
I've actually, I no longer even do these cases. I'm only on this case because of how complicated it is. And that essentially giving it to another prosecutor would no longer make sense. And so no, he could write a request to my supervisor and ask that I be removed from this case. I would have no objection to that. It does not matter to me. I don't have a choice. That's not my choice to make. He can make the request to my supervisors and they will make that decision whether or not I should be removed from this case.
She handles the cases they assign to her.
And she's handled this case poorly due to the information that she received.
According to you. And once again, you don't get to control things. You don't pick your prosecutor, just like you don't get to pick your attorney unless you hire that attorney. Move on. We're going to do the 404B now. Is there anything else before we do that?
We can move on.
All right. Anything? Go ahead.
Yes, I do, Judge. Just based on our last hearing when we were here about certain things for me to follow up on, I do have just things that I want to put on the record and share. So I was going through my file with the police reports. One of the statements I had in my possession from the police that Ms. Green had written was missing the page 2 in my file. I don't know if it was missing the page 2 in his file. So I have the full statement essentially, just in case. I don't know if what technically was uploaded and I downloaded onto mine is what he received.
Understood.
So that's the first thing. The second thing is there were requests for emails from the police between essentially what emails Ms. Green, the complainant, sent to the police department. Those were actually all included in the initial police report. And so I have another copy of the initial police report and then separately the emails that were attached as supplements for Mr. Phillips. So I have those as well. And then lastly, I requested any of the supplemental reports that the police have essentially written since the original report, because they often will, essentially anything that they do, they create subs.
Right.
And so after last week, just because of all of the discovery issues that we had, I requested that and I have the following of it. Essentially, it's a continuation. I believe his ends at page 19. This then starts at page 19 and it goes, so I have the rest of that. So I just wanted to make a record that I'm turning these 4 documents over to the defendant based on our last appearance.
And there's an objection. So in regards to that,
there is no regards to that.
There's a continuing duty to disclose.
But you're objecting to her giving you that?
All these months.
Are you objecting to her giving you that?
I'm objecting to what she stated. I'll review what she has. Doesn't make it true, but I'll review it.
And I would like to actually know, I think he actually has all of these because he's forwarded them and the police department actually told me that he has them. If anything, I didn't have the stuff because I hadn't requested it before. So I just wanted to make sure that's very clear in regards to what I had and what I was turning over.
Okay. All right. So I took another opportunity last week to review the pleadings that have been filed on the 404B motions, both plaintiffs or prosecutors and defense. Anything either one of you want to add to your briefs and pleadings? Ms. Richardson?
Judge, the only other thing I think that might be relevant, and I don't have the documentation for you, I've been trying to gather it, is it's my understanding that, again, the defendant has essentially filed another PPO against the complainant in Washington County. She is being represented separately for that. That was dismissed again. And it's just to show that continuing pattern of essentially what my motion. What my motion.
You can't object to her argument during the motion.
What my motion addresses, which is this pattern of using certain entities to continue to harass the complainant. There was essentially no foundation for that motion. Again, I don't have the paperwork. I'm trying to get it from the Washington courts, but I do think just again to add based on what I had previously stated, and this was maybe less than 2 weeks ago, she notified me that this had happened.
Okay.
And I would just like to add, Your Honor.
I didn't ask you.
Oh,
I didn't ask
okay.
you.
Oh,
Is there
go on,
anything
Harry.
you want to add to your written pleadings?
Absolutely. In regards to this complex complaining witness and prosecutor in regards to this matter, that individual, Ms. Santania Green, has contacted me through various modes, which prompt a request for a PPO, because I have rights and I'm going to protect myself. Okay? So we're not going to do
Okay.
gender-based
Okay,
violence.
you don't have to defend it.
Okay.
She's just letting you know that that's one of the things that's under 404B she's
Mhm.
seeking to use against you
Yeah.
in trial.
And I'm letting
You
her
don't have to
know.
respond to it now because there's the truth or veracity of that is not being decided today.
Yeah.
She's letting you know that's one of the long list of things that she wants to include under 404B. So there's no response necessary to that. My question is, other than what you've submitted on paper as to 404B, both your request and hers, is there anything you'd like to add to your pleadings?
Absolutely. I spoke to it. I'll say it again. Ms. Green, the complaining witness, has contacted me through various
I
modes.
don't care.
I do.
Well, it doesn't matter what you care. I don't care. I don't need to hear that. Whether or not you had justification for seeking the PPO isn't even on the table today. The truth or untruth of what Ms. Moisisian said is not important right now. What's important is she's letting you know that she wants to include that under 404B.
Yeah, she's just misrepresenting information that's filed upon the court.
Which, once again, according to you. So I'm going to ask one more time, and then I'm not going to let you talk anymore. Is there anything you want to add to your pleadings other than this Washtenaw County PPO thing?
Yes. The complaining witness also had our son place a AirTag tracking device in my vehicle on 12/15, the day of the parenting time exchange from Livonia Police Department. It was then heard and discovered in the vehicle off the minor's person in my vehicle. I then checked his phone because he unlocked it willingly, no issue.
Let me stop you for a minute.
Go ahead.
Are you telling me that because you're letting her know that that's some of the 404B that you want to talk about on the day of trial?
I'm gonna add it all. She's gonna hear it all.
Okay, I just. Sure, we'll do it. Yeah, put it together. Yeah. All right, so she's on notice, I'm on notice. Got it. Anything else as to the motion that's up today? Motions that are up today?
Yes, so in regards to that, that is a direct violation and it's a cause for dismissal, a swift dismissal. Because it's violating me, it's causing terror, and it's 2 or more non-continuous acts as well.
So even if Ms. Green was standing in front of me right now and admitted doing that, that would not be grounds to dismiss this action.
Well, she already lied in regards to the whole entire 6 allegations.
Which,
okay.
you heard what I said, and that had nothing to do with the 404B. So don't talk anymore because I've given you 3 opportunities and you haven't taken them. So I'm ready to rule on the pleadings. I'm denying all of your 404B motions because the proof is exactly what we just went through today. Under 403, and I'm going to read it because I think the whole damn thing applies to this case. Although relevant, and we can question whether or not all this stuff would be, evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, or misleading the jury, or by considerations of undue delay, waste of time, or needless presentation of cumulative evidence. Everything I'm hearing from you is almost all of those things, and most of what I'm hearing from you is just going to confuse the hell out of everybody. So we're going to talk about July 18 to August 10 and January 14, and that's all we're going to talk about on the day of trial. We're not getting into anything past, anything beyond that. That range of dates in that January 14th date is all we're going to hear about when the jury's in the building, which is when? January 29th? All right, now, are you still seeking a court-appointed attorney? Because my understanding is they're just waiting for you to fill out some paperwork before they can process that.
Who is they? I don't know who they is.
MIDC.
Oh.
My understanding is you didn't want to fill out the paperwork Ms. Patton asked you to fill out.
She never asked me to fill out anything.
I sent it to him and he did not fill it out. And that's what they need.
Your name is Miss Mortsfield, not Miss Patton. Miss Patton never gave me anything.
Well, did Ms. Mortsfield send you something about a court-appointed
Yes, she
attorney?
did.
Did you fill it out?
I did not.
That's why you don't have an attorney. Have a nice day.
I didn't request one.
Goodbye.
Okay, that guy was crazy. So we're gonna see him. We're gonna see him coming on in January. We have to wait till January, but this guy, next guy, is just as crazy. Don't worry, but he's in custody. Here, let's just go.
Greetings, Sir Honor. Presenting today in open court, Mr.
Good
Cross
afternoon.
litigant, Mr. Dr. Victor Robinson.
So you're Victor Robinson. All right, we'll go on the record in state of Kansas versus Victor Dwayne Robinson, 23 TR 3599. The state appears by Devin Canfield. Mr. Robinson appears in custody from the Butler County Jail. Mr. Robinson, you're here for a first appearance. Have you received a copy of your charging document?
No.
All right, I'll read your charge to you at this time. On or about the 13th day of December 2023 in Butler County, Kansas, Victor Dwayne Robinson did unlawfully and contrary to the rules and regulations established by the Secretary of Transportation misuse a controlled access highway or facility within the jurisdiction of the Secretary of Transportation by any class or kind of traffic which is found to be incompatible with the normal and safe movements of traffic. That is misuse of controlled access highway and facilities. That is a Class B non-person misdemeanor, carries a maximum penalty of 6 months in jail and up to a $1,000 fine. Do you understand your charge, Mr. Robinson?
Oh, sir, the incident, I was stranded on the highway. I'm not saying that I'm guilty of it. However, I was stranded on the highway and I was carrying the automotive battery. And the officer or the trooper could have gave a warning. He did, and then he arrested him, man, after we jump-started the car and everything. And he towed the car illegally, and I had to simply miss court in another jurisdiction. He could have just gave a warning. He ordered him, man. Been sitting in jail for 3 days now. I have nightmares, punitive nightmares, and I just do not understand. It's all confusing, to be honest.
All right, Mr. Robinson, you may very well have a defense to the charge. I don't want you to say anything that might incriminate you. Do you wish to consult with an attorney regarding these charges?
Is there any way we can give a warning and dismiss this as far as in?
Well, not right now. I don't have the authority to do that. That's something you'd have to visit with the county attorney's office about, but that's not something we'd be able to do today.
All right.
Today, I'm just here to tell you what your charge is. You can enter a not guilty plea, you can enter a guilty plea, you can enter a no contest plea. Those are your three options. If you wish to consult with an attorney and perhaps negotiate a plea that would have it dismissed or consider a diversion or some sort of alternative disposition, you might want to do that. I'm not sure what the state would recommend if you were convicted of this charge, but those are the options available to you today, Mr. Robinson.
I would just seek to lower bond if possible, please, for right now.
We'll discuss bond here in a minute. Do you want to go ahead and enter a not guilty plea then?
No, I need to go ahead and talk with someone else regarding this matter. I have no idea what's really truly going on, other than what you just read off on the paper.
Okay. Well, I'm going to enter a not guilty plea for you. Can you afford to hire your own attorney, or do you wish to apply for court-appointed counsel? If you can't afford to hire an attorney, one would be appointed for you.
So am I being under duress as far as in entering that plea not guilty? I just said I have no idea what's going on. I'm not aware of exactly what's going on for a man to even make a plea.
Well, if you wish to consult with somebody about what's going on, then that's just the normal procedure. You can always change your plea at some point, or ultimately you could just take your case to trial.
It's just going to exacerbate the situation even worse. I will sue the trooper and I will sue anybody that's attached to this case. I have not gone in no one's favor to be sitting in jail over being stranded on the highway. I was literally stranded in a vehicle. And the car battery, I was looking to get it to the nearest auto shop to recharge the battery. And the trooper, he had some type of hyperbolic hysteria emotion about the matter. I have no idea why a man is still sitting in jail at this point, other than the constitutional rights of a man's process.
All right, Mr. Robinson, I'm gonna enter a not guilty plea for you. I'm gonna set your case in front of Judge Webster on March 4th at 9 o'clock in the morning. That's a Zoom hearing. Mr. Canfield, what's your recommendation for bond?
Your Honor, this is not my case. I did not charge this case, but after reading the affidavit, I believe a $100 OR bond would be sufficient.
Do you live in Lawrence?
I'm not able to answer that. That's a conundrum question. Without a lawyer, I'm not answering no more questions, sir. I have no idea why I'm still sitting in jail. I truly do not. If y'all two is in this position, y'all will not be happy either.
I'm setting a bond in the amount of $100 OR, which means you don't have to put up any cash if you don't appear in court. Then you could be ordered to pay that money back. So you can sign yourself out of jail this afternoon if you don't have any other holds. Your court date is March 4th at 9 a.m. That's a Zoom hearing in front of Judge Webster. Going back to an attorney, can you afford to hire your own attorney, or do you want to apply for court-appointed counsel?
So I'm stranded. Once I leave here, I'm stranded. I have to walk, and I'm going to get arrested again, of course, because now I'm on a highway or that. It's difficult for y'all to sit up here and put us in these little booby traps and expect us to not accommodate or make y'all aware. I have no idea what to do at this point. I cannot call no ride. I cannot call no one because of I have no idea, to be honest. How y'all like a man to handle it?
I'm going to appoint Darren Patterson to represent you. He's an attorney here in El Dorado. That way you'll have an attorney appointed. If you wish to hire somebody of your own, you can certainly do that, but at least you'll have an attorney representing you at this point. They should be able to provide you with his contact information. So I'm ordering that you be released on an OR bond. So anything else, Mr. Canfield?
No, Your Honor.
All right, anything else, Mr. Robinson?
No, sir, Honor.
All right, we'll be in recess. You are excused. Thank you.
So Webster's going to get him. Now, I sort of agree with him because I didn't agree with him because of all the craziness. This man says you can't charge someone, blah, blah. But once the prosecutor said, this isn't my case, just give him a $100 OR bond, he doesn't believe this guy should have been charged. And if the prosecutor doesn't believe this guy's should have been charged, then I don't know why he's in jail. And it sucks to be in jail for no reason. I mean, that's horrible. I couldn't even imagine just having to sit in jail. Maybe there's a reason. Maybe they'll find a reason why he was put in jail. I don't know. But right now, there's nothing. And the prosecutor knows it, and the judge knows it, and this guy knows it, and he's still in jail. So Judge Webster will get him. And we love Judge Webster. But hopefully, he wasn't that crazy. He was just a little crazy. Like, I'm not giving you my address. The man's not giving you his address because the man doesn't understand why he's in here. It's a conundrum. It's a conundrum question. But we'll see what happens with him. I know you guys watch Judge Webster, so if I miss it, somebody let me know what happens. Also, another thing, if somebody can let me know, Janelle. Listen, I have no idea if she ever got her driver's license. And I can't go back through Mike's videos to find out. But I'm dying to know if she ever got her driver's license. So if anybody knows if Janelle got her driver's license, someone let me know. All right. So guys, if you remember in Reno, We had a guy twice on here, on my videos, or three times. I can't remember. So the guy was at the laundromat, and he was doing heroin at the laundromat. So he got trespassed from the laundromat, and then he went back and got trespassed, and went back and got trespassed. Failure to appear in court. But this guy also was charged with another crime. I think it was 3 a.m. At 3 a.m., he was banging on some single mom's front door, side door, back door, screaming for this one lady who didn't live there. And, the mom was alone with the baby in the house, or 1 year old or 2 year old, something like that. And she called the neighbors, and she called the cops. And she's like, there's this guy trying to break into my window. Um, he failed to appear for that case. So we have an update. We have an update on him. I don't think they talk about the trespass from the laundromats in this update, just this other trespass case, or I don't know what it is. Here we go. Oh, he had hair and a beard. He had a full
Richard Irwin,
thing of hair and a long beard in his last two videos.
I have two matters for Mr. Irwin.
Yes, ma'am.
Good morning, Mr. Irwin.
Good morning, ma'am.
The first matter I have for you is 23 CR 15067. And sir, that is a charge in a complaint. Complaint was filed December the 4th, 2023, and charges you with possession of drug paraphernalia and trespassing. The trespassing is alleged to have occurred at the washboard laundry.
And Judge, if I may interrupt, this one's actually a revocation hearing. He's got a 5-day sentence. And then his other case, I was told, is a sentencing.
It is on a disturbing the peace.
Right, I recall this from yesterday.
Thank you.
Thank you, Mr. Puentes, for reminding me. So I'll hear from the city. Let's start with the disturbing the peace. I think that's the reason that we bumped this over till today. So to see if the city could make contact. I'm familiar with the facts of the case that he was pounding on someone's door at 2:30 in the morning, not only waking up the household, but the neighbors who also filled out a police report relative to the noise disturbance. What's your position, Ms. Cielo?
Your Honor, the question that I had when I read through the facts of the case is what precipitated this behavior. It's somebody's home that I don't believe that he has any knowledge who lives there, or that he doesn't know the person. So I don't know what was going through his head, but I was hoping we could explore the fundamental issue and try to steer him in the direction of treatment. If it was drug related, maybe go in that direction. But with that in mind, I would request a 60-day suspended sentence for 2 years with no contact, and then sort of probe into what the fundamental issue is so that we can keep this from happening again, but also get the defendant some help.
Thank you, Michelle. Mr. Puentes, any insight relative to the city attorney's concerns?
I don't have insight, Judge. I do know that this happened way back in July. He's got a separate address from where this occurred. And I also know he's been in almost 2 weeks. So we'd ask Your Honor for a short suspended sentence with the no bail laws clause, and that he not return to this address. And then if you're inclined to revoke on the 5-day suspended sentence on the other case, we'd ask that it run concurrently.
Thank you. So, Mr. Irwin, the question of the moment is, what in God's green earth caused you to go knock on somebody's door at 2:30 in the morning? And it wasn't just knocking on the door. It was pounding and screaming and threatening to break a window. So some pretty malicious behavior. What caused you to do that?
Not really certain. I thought I knew the girl that lived there. When I rang the doorbell, a guy answered that I didn't know. And I asked him, I said, is Miranda there? And he said, no, wait a minute. Well, we've been here for a couple of years. And I said, well, I thought I knew the person here. I'm sorry. And I turned around and walked off. And then a couple blocks later, the cops showed up and asked me what happened. And I said, there really wasn't much going on. And he said, the garbage cans next door were, or next to the house were turned over, and they were worried that, they were worried about you, so they called the police. That's all I know. No.
Okay, well, that's not exactly what the witnesses say. They were quite nervous that you were causing quite a ruckus for them, and I wanted to read you what the neighbor said because it was kind of chilling. So the witness statements say, about 2:30 a.m., I was woken up to someone banging and screaming at my front door. I woke up scared, ran to living room and saw a shadow in my living room window. I then called my neighbor. My 3-year-old daughter called her, my neighbor. I think it says 3. My daughter called 911. I saw him in the window and heard him trying to break in the window. My neighbor, it looks like something, and told him to get away. And that's right when the officer showed up. So it's a little more violent than you made it sound, Mr. Irwin, and I'm concerned too. So were you on drugs or alcohol that night?
No, ma'am.
Do you have a substance abuse problem?
No, ma'am.
Okay. So you don't need any kind of treatment? This is just your normal behavior?
No, I don't need drug or alcohol addiction treatment.
Okay. All right. Well, based on what I've
He
heard
does.
here today, I'm going to go ahead and revoke the 5-day sentence that was suspended for you. And I will give you credit for the 5 days you've already served. But I'm going to sentence you to 45 days in the Washoe County Jail. That sentence will be suspended for a period of 2 years on the following conditions. That you obey all laws. You have no alcohol or drugs without a valid prescription, including marijuana. And that you stay away from the address listed here, and that is 230 Galloway Lane in Reno, Nevada, and the person of Anita Barajas. If you have any contact with those people, you're going to go back to jail and you'll serve 45 days. Do you understand, sir?
Yes, ma'am.
All right. Do you have any questions about my sentence or my conditions?
No, ma'am.
All right. That will be my order.
Thank you. I appreciate it.
Your Honor, did you want a no contact or a stay away?
No contact, please.
Thank you.
So you probably need to stick around, Mr. Irwin, so you can sign the no contact order, okay? All right, the next matter I have is.
We'll see him again. He keeps coming back. He just is always in court. Always. All right, so let's go to a bond, a poor bond.
Get to the jail, the Clinton County Jail needs to be ready.
Love this judge too.
Commonwealth versus William Shickles. Is the purpose of for the purpose of arraignment. Yes, sir.
I'm on it, Mom. The motion for me to come up here. So, Judge, it's my understanding, and that I apologize. What's your name, sir? Connery. That Mr. Condrey is wanting to be removed as.
Okay, well, Mr. Shickles is present in the courtroom. I'll sign and release you. He's in custody. Okay, thank you.
That's the first time I've ever seen that. So that guy works for a bonding company, and he gave this guy a bond, and he brought him into the jail today, and he's asking to be released from that bond. So the judge released him from the bond, and now this guy doesn't have a bond anymore. That's the first time I saw a bonding company bring a guy in and ask to be removed.
Thank you. Commonwealth versus William Shickles for purpose of arraignment. This is 23 CR 0052. The grand jury of Clinton County has returned an indictment charging you with trafficking in controlled substance first degree, possession of controlled substance in the first degree, methamphetamine, operating a motor vehicle on expired license, and possession of drug paraphernalia. You understand those charges? Yes. Okay. We have a reciprocal discovery order I'm signing. to be here on January the 5th for the negotiation date, and the next trial date, the next pre-trial conference date here is on January 11th. Okay, now since we have one bailiff here, I need some cooperation with you here. I want this gentleman is in custody. Since we don't have anybody to watch him or transport him, he needs to be cuffed.
Judge, I would ask, and
I'm not finished yet. You can ask something when I get finished, okay? So when we get finished with him here, he needs to be cuffed until they come up and transport him. Now, you've got something to say.
And Judge, it was in relation to the cuffing. Judge, I know we didn't hear a reason as to why.
You didn't have to give a reason.
You said it why. Well, hold on, let me talk, okay? Judge, we would ask that Mr. Shickles be permitted to stay out on bond.
I'll be glad to do a bond review if you want to file a motion for bond reduction. I had a bond set and he was able to make it and he was free. If someone comes up here and asks to be removed from the bond, they don't have to give any reason. And I have no reason to change my previous bond decision at this juncture. So that's the way it is. Now, if you want to take a look, see if he gets somebody else that's acceptable to the court, don't say anything yet. Put him in cuffs and take him back in the room. You'll be around here to help.
Okay, so in that courtroom, Judge Williams says that a lot. Put him in cuffs. Put him in cuffs. Take him into custody. Take him into custody. All the time. And they put him in cuffs right there. But the problem in that courtroom is there's only one sheriff. There's only one bailiff there. And the judge keeps saying, put him in cuffs, put him in cuffs. But there's only one guy. So all the time you see this judge say the same thing. Call the sheriff. Get more bailiffs here because you can't handle this alone. Call the sheriff. Get more bailiffs here. You can't handle this alone. And he just keeps putting people in cuffs over and over and over again. And this poor bailiff's trying as hard as he can, but let's stay in his courtroom. Let's go for one more in his courtroom.
Michael Turner.
Yes, sir.
Hey, Commonwealth versus Michael Turner, 23 CR 0055. Mr. Turner, were you born in 1967?
Yes, sir.
That's 4 digits of social security number 1161.
So
we're here for a pretrial conference. What's the story here?
Judge, you may not recall last time, Mr. Turner actually fired me. I have contacted the main DPA office seeking conflict counsel. Due to Judge Costello having a docket, I don't think anyone else from the DPA was available today. In fact, I'm covering some of their cases. So
what are you telling me?
Well, Judge,
that he needs another lawyer and y'all hadn't lined him up.
Correct.
Okay. What is he charged with?
Convicted felon in possession of a firearm.
Okay. Well, I'm going to set it for a conference day on January 12th, and I want a specific order directed to the Office of Public Advocacy to provide him with an attorney in time for them to go over and meet with Mr. Turner and prepare for that negotiation. I want them to talk to him before he gets to negotiation. His next court date will be January 18th.
Yes, Your Honor.
Okay, thank you very much, Mr. Turner.
What about the bond? I'm on 25,000 cash only. I've been locked up now for about 6 months on this charge, stopping the guy from shooting me.
Yeah, well,
that's.
I'm trying to get you a lawyer lined up. You fired your other lawyer, and I wasn't aware of that until today. What are the circumstances?
Evidently, he was in a dispute with 2 other people, and he was arrested because he had a firearm on his possession. The other 2 people didn't want to prosecute him, but he was arrested because he was a felon in possession of the firearm.
Yeah.
Well, that's not true, Your Honor.
I'm just
That-
telling you what the police report said. That's all I'm telling you.
The police thing, just tell you, I've been shot and everything else over this, over my property. I've even been drugged and gang raped and poisoned, and I'm one locked up. Now this is a kangaroo court. Now I'm not being railroaded by a small court, and now they're trying to do it here. I'm not saying you are, Your Honor.
That's good that you didn't say that.
I mean, you're twice.
I wasn't aware that you didn't have.
It wouldn't.
But here's the thing about it is I'm going to try to get an attorney appointed for you immediately to come over and talk to you. And then because you've been there as long as you have, and out of consideration of the fact that you weren't appointed somebody as quickly as I'd like, I will have a special hearing about this as soon as we can get somebody to talk to you. I don't want you to say anything else that might incriminate you. You understand what I'm saying? But I understand your frustration. So we'll have somebody over there post-haste, okay?
And even medical attention about the bullets, I'm still packing where I've been shot. And
they'll come over and talk to you and bring anything to my attention, okay? So you're on my radar now, Mr. Turner, okay? Okay, thank you very much. Sonny Voorhees.
So the judge was really nice to him. He fired his lawyer. He didn't have another lawyer. So, he sort of did this to himself. But the judge is nice to him, and is getting him help. And then we'll see him back. Poor guy had a lot of things going on. But, yeah. So, yeah. Thank you all for coming out today. As soon as I started this stream, chaos went on in my home. And I've been trying to concentrate on this stream and deal with chaos this whole time. So if I was distracted, I didn't mean it. I can't help it. It just happened. But I have way more stuff. I'm going to get that out to you as soon as I can. Probably later tonight. I might do a late stream from England. It's only 30 minutes long, but it's horrific. Like it's not horrific. It's not anything like that. I would never post anything like that. But it is pretty bad. It is pretty bad. So yeah, I'm gonna put that on later tonight. So if you're around, stop by later and see me. Guys, it was great. Great stream. Thanks a lot. Have a good day.